Hello, this is Matt on the Moon Lambo channel. The SEC filed a brand new lawsuit today against cryptocurrency exchange Kraken, claiming a number of things, including co-mingling of funds. Yes, customer funds. That's a rather big claim, especially after what we saw happen with FTX a year ago, when that Ponzi collapsed. Also claiming that specific cryptocurrencies are themselves securities. Didn't we just deal with this in the SEC v. Ripple case? And they list, if I counted correctly, I want to say 16 different cryptocurrencies that are securities, just by the nature of them existing. But you know what cryptocurrency isn't listed? You want to take a guess in the comment section below? Go ahead. Take the guess. All right, I'll tell you what it is. It's XRP. XRP is absolutely and noticeably not listed. Well, how about that? So I'm going to share with you, I'll get you up to date on everything that's happening here, but I also want to share with you perspective from a few attorneys within the XRP community, including attorney John Deaton, attorney Jeremy Hogan, and attorney Fred Rispoli. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, you might be wondering, are you having deja vu? Because isn't this something that was settled earlier this year? Yes. So it's a whole new slew of claims this time. But look at this headline from February 9th of this year from CNBC. Crypto exchange Kraken settles with SEC for $30 million, will close U.S. staking operation. And so that whole case, I was just using this as a little table setter. I don't want to go through the past stuff any further, but I'm just noting, yeah, they paid the SEC $30 million to get them off their backs, only to get sued again later in the year. Maybe instead of settling, they should have attacked back. They should have fought back. Because playing nice with the SEC, trying to appease them, even with $30 million, which is undeserved, even that is not enough to get them off your back. You have to push back. And so here's the headline from today. SEC sues Kraken, alleging it's unregistered exchange, alleging it's an unregistered exchange, mixes user funds. So from Cointelegraph, the United States Securities and Exchange Commission has sued Kraken, alleging it commingled customer funds and failed to register with the regulator as a securities exchange, broker, dealer, and clearing agency. In a November 20th complaint filed in San Francisco federal court, the SEC claimed that since 2018, Kraken had operated as a platform that unlawfully facilitated the buying and selling of cryptocurrencies. Now, folks, think about this. They knew that they wanted to come after Kraken for separate charges. They could have had everything in one suit because there were all sorts of allegations. They wanted the opportunity to come back for a second round. Think about that. These people are disgusting and devious. My God. Piece continues. A Kraken spokesperson told Cointelegraph it disagrees with the SEC's complaint and plans to defend itself in court. The lawsuit marks the latest push from the Gary Gensler-led agency to bring crypto under its purview, claiming that crypto assets are securities contracts under U.S. law. Quote, without registering with the SEC in any capacity, Kraken has simultaneously acted as a broker, dealer, exchange, and clearing agency with respect to these crypto asset securities. End quote. There you go. They're making up a new category. Crypto asset securities, man. Now, of course, that's not in the definition of what a security is or what an investment contract is. You know, crypto's nowhere to be seen there. You know, stocks are listed, but digital assets aren't. Cryptocurrencies aren't. They just made up a thing here. And then they're just trying to have a court enforce it and seeing if they can get away with that. Piece continues. Additionally, the SEC alleged Kraken's business practices and deficient internal controls saw the exchange commingle up to $33 billion worth of customer assets with its own. The SEC said this resulted in a significant risk of loss for its clients. The complaint claimed Kraken paid for operational expenses directly from accounts containing customer assets, citing the exchange's independent auditor. We allege that Kraken made a business decision to reap hundreds of millions of dollars from investors rather than coming into compliance with the securities laws, SEC Enforcement Division Director Gerber Gruhl said in a statement. That decision resulted in a business model rife with conflicts of interest that placed investors' funds at risk. Now, Kraken pushed back against the SEC's accusations with a spokesperson saying the exchange never listed unregistered securities. Quote, we disagree with the SEC's complaint against Kraken, stand firm in our view that we do not list securities and plan to vigorously defend our position. End quote. And then they wrote, it is disappointing to see the SEC continue down its path of regulation by enforcement, which harms American consumers, stunts innovation, and damages U.S. competitiveness globally, the spokesperson said. And here's the part where they do address the co-mingling of funds. In a follow-up November 20th blog post, Kraken addressed the co-mingling accusations by saying that the SEC cannot claim that any customer funds are missing, adding that the so-called co-mingling is no more than Kraken spending fees it has already earned, end quote. So I wouldn't be surprised if it's a completely bogus accusation from the SEC, because it's the SEC and they're asshats. They're complete pricks. They are spawns of Satan. Winged spawns of Satan. And then we have this from Dave Ripley. This is the CEO of Kraken. He wrote, "We strongly disagree with the SEC claims, stand firm in our view that we do not list securities, and plan to vigorously defend our position. As we have seen before, the SEC argues that Kraken should come in and register with the agency when there is no clear path to registration. Its allegations are factually incorrect, contrary to law, and the wrong way to create policy in the United States. As an industry leader, we will stand up to these allegations and defend the crypto industry's right to exist in the United States. We believe congressional action is the most appropriate path to resolving the lack of regulatory clarity in the United States, and will continue to support these efforts to bring clarity and certainty to the chaotic environment that has been created in the U.S." So it just got to make you wonder, are they going to push back this time? Are they going to really fight back or acquiesce further and see what happened? We're going to find out. I mean, I'm hoping that they learned their lesson at this point. And I'm very sympathetic to them. I hope it doesn't come across too harsh or in a way that I don't intend, because I get it. Even if you have, the fortitude, the mental fortitude necessary to wage a multi-year battle against the SEC, the question is, can you afford to? So hopefully for them, the answer is yes. But anyway, Attorney Deaton reposted that and said, "Tomorrow I will post a Google form for Kraken customers/users who are sick and tired of the SEC pretending to protect digital asset holders from legitimate good businesses like Kraken. We will fight to have our own voices heard and not let the SEC speak for us." And so, folks, Deaton is doing the same thing he did in the SEC v. Ripple case, which had an incredible impact. He's doing that also in the Coinbase case right now, and he plans to do it here for Kraken starting tomorrow. And I'm sure a lot of you are going to want to sign up for that. And then there was also this. Attorney Deaton wrote, "Make no mistake about it. The SEC is worried about the Coinbase motion to dismiss pending in the Southern District of New York. This case is filed in the Northern District of California." Actually, you know what? I've got a separate post from him talking about that as well. He wrote, the SEC filed, this is Deaton again, the SEC filed against Library in the First Circuit, filed against Ripple and Coinbase in the Second Circuit, filed against Dragon Chain and Kraken in the Ninth Circuit. Gary Gensler is hedging his bets. He will ultimately lose. And so you see the strategy here? They're filing all over the place, broad exposure to various aspects of whatever he perceives would be coming in these particular circuits. And he's just counting on different judges in different areas acting differently. He's just kind of spreading out the risk. That's what he's doing here. And so that's why he's filed this in California. This latest Kraken case is filed in California. And then there was also this from Attorney Jeremy Hogan. Apparently, the $30 million the SEC got from Kraken back in February wasn't enough. It had to sue them again for more. Everyone feel protected again? See, that's one of the most disgusting things about this. This is harming people that they're sworn to protect. Who out there feels protected by any of this behavior? You would struggle to find one person that would be like, "Oh yeah, I feel way safer, genuinely." Good luck even finding one person. And then Attorney Hogan also shared this post. He wrote, "Guess which crypto is not included on the list of alleged securities?" And if you guessed XRP, you're right. Now, fine, technically there's over 20,000 coins and they list 16, but you know what he's getting at here. And so here's the list. I'm not going to read them all, but there's, I think, if I counted correctly earlier, I think there's 16 of them. But XRP not listed. And it's so ridiculous because if you think back to the SEC v. Ripple case, even the SEC filed a document to Judge Torres and said, "We are not going to appeal the decision that XRP itself is not a security." And they went out of the way to make it sound silly. The concept would be silly to appeal that because it's just computer code. It's just computer code with no inherent value. That's what they said. Yet here they're calling these specific assets crypto asset securities. These people are disgusting liars. They don't believe the crap they're arguing. They're just trying to get away with it because that's what they want because reasons. Somebody wrote to Attorney Hogan named Tekanoshi and wrote, "They bent over too easy the first time, now an easy target." Attorney Hogan responded and said, "Completely agree. The staking lawsuit from February wasn't that strong either." So look, Kraken probably would have done great in courts. They settled, they paid the fine, and now they get to do it all over again. It's just gross. Here's a post from attorney Fred Rispoli. "Much like the first thing one should do when seeing a misbehaving child is blame the parents, you gotta wonder what Kraken's lawyer was thinking when he agreed to SEC's stupid fake penalty the first time around." I would love to know too. And again, I'm trying to not be too harsh on Kraken. They are the victims here, but they're also harming the business model, which means the livelihood of the people that work there, and certainly, obviously, the customers. But you do kind of gotta wonder: did they literally not think they had the money to fight this, or were they just a bit limp-wristed? It's got to be one or the other, right? So here we are, but XRP's in the clear, and hopefully the whole Coinbase thing just gets thrown out. I don't know. I mean, that would be wild. That would be such. Can you imagine? We get that news, the stunning defeat of. All I want for Christmas, man. All I want for Christmas. We already got our XRP legal clarity, so that's all I want for Christmas. That and $25 XRP. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.